Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because at that time, we have a deal that my clients will
say.
Listening to both the attorney and the defendant is honestly ready to take a plea deal without even purposely in circles. That's dragging just everything out just to fill time. Honestly, instead of being straightforward, public defender could probably provide the same level of representation, giving Judge Simpson the longest runaround imaginable. It's like paying luxury prices for a judge's patients wearing gotten for free, and eventually, the craziest he just loses it. The lawyer shouting at the lawyer to get their act together, but still walks away with money from the defendant. It's hard to blame him. If he had just done the basic discuss a plea deal, this case would already be closed. Done. Instead, it's a mix of awkwardness and comedy at the same time. Reviewing there's also a layer of frustration for anyone trying to follow getting paid to fix the messy. Some of these lawyers seem to treat courtroom chaos the system allows part of their game plan to turn confusion into profit. Let's dive in and see exactly how this unfolds. How did this guy even pass It's a roller coaster you won't want to miss. Did he cheat? Or was the exam just generous that year? I actually feel for the defendant here. This might be one of those rare moments where the client is smarter than their lawyer. It really makes you wonder how many other cases suffer from lazy representation. What do you guys think? Maybe I'm being a little harsh, but shouldn't courts start holding lawyers accountable when they...
Courthouse case, People versus Rashad Ahmad.
Ready, Your Honor. Good afternoon, Your Honor. Hassam Qudsi on behalf of the defendant.
Rashad Ahmad. I have a plea form in front of me that indicates that the defendant is going to be pleading guilty to attempted interfering with electronic communications. That's a 1-year misdemeanor. That's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay full restitution, and there's a sentence agreement, although the court, I cannot bind the sentencing judge. In this case, there's an agreement to no upfront jail. The prosecutor and defendants are agreeing to that.
That's correct.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Rashad Ahmad.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted interfering with electronic communications. That is a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. Do you understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Still wish to plead guilty?
Sorry?
Do you still wish to plead guilty to this charge?
Your Honor, may I say something? Just something happened. The victim is here. Just want to let you know.
Okay.
And may I approach, Your Honor?
Yeah.
I'm sorry about that.
All right, sir, understanding the maximum penalties in this case, do you still wish to plead guilty to this charge?
Yes, sir.
And to that charge, how do you plead?
Yes, sir.
How do you plead? Guilty or not guilty?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Yes, sir.
Do you have any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
July 8th, 2025, at the location of 1480 Parkwood Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. What did you do what did you do that makes you think that you're guilty of the offense of attempted interference?
May I form the question, Your Honor? I'm sorry. Did you text her? You put a daughter via Zelle and text her? Did you do that?
After the court, you mean?
No. The judge is asking you, did you text her? Did you text her, send a text message via Zelle?
Yeah. Yes, I did.
So, this guy pleads guilty to attempted interference, and somehow the confusion multiplies because his own lawyer seems just as lost as he is. It's one thing when a defendant struggles to follow along, but when the attorney is stumbling over simple words, the courtroom starts to feel more like a failed language lesson than a legal proceeding. Judge Simpson is doing his best to stay composed, but you can almost hear the mental facepalm echoing through the room. The attorney is supposed to interpret and clarify the law, not twist it into something unrecognizable. And here's the real problem. Pleading guilty without clear understanding can actually invalidate the plea later on, because the court must confirm that the defendant fully grasps what's happening. That's why judges repeat themselves over and over. It's not theatrics, it's essential legal protection. Yet even that isn't helping here. The lawyer keeps responding with and
I don't know how that,
It's like it was send money. It's not text.
Yeah, I know.
Yeah.
how does that, I don't know how I get to the charge.
This is the only electronic device that he attempted to do. He was texting her, giving her $1 through Zelle so he can text her a message.
Sir, I'm just saying, whatever is being said to me doesn't sound like the offense.
Mr. Ahmad, on that date, were you with a Kimberly Chavaria?
مش فاهم.
He doesn't understand.
Like,
Who is
no,
this Kimberly? I want to he's saying. He doesn't understand. ما نكسبها بالاسم Kimberly?
Yeah, هي اسمها. Yeah.
She's asking you, you were with her on
Yeah.
that date?
Yeah.
Okay.
And on that date, did she try to contact 911?
Yeah.
And did you take the phone from her?
No, I didn't take the phone because she didn't try with the phone. She did try with Alexa
Did you tell Alexa to stop calling 911?
because Alexa said just one time because Alexa said she can't call 111 and start talking something else. That's why I stopped Alexa because Alexa didn't like how we can say
So you stopped Alexa from calling 911?
and not for calling no. Alexa after she called 911 and Alexa it doesn't work for call 911 and they start talking like
Did you take her phone from her at some point?
no.
All right, well, I can't accept the plea. I don't have a factual basis.
Your Honor, so we do a preliminary exam? Your Honor, right,
Okay,
asking.
there will be a preliminary exam set. I will assume that all discovery is complete.
Oh, no, there was.
I will assume.
Your Honor, there was
Trial
no
can't
discovery.
accept a plea. Pardon?
There was no discovery. We didn't get any documents, police report or anything. Because at that time, we thought that we have
Well, why am I taking a plea if there's no, this doesn't even make any sense. What?
Your Honor, in my file, discovery is tendered. You've sent over the media as well as the 911 call has been uploaded.
I never received it, Your Honor, 100%.
Was it sent to him? He's been the only attorney on the case, so.
There was another attorney before me, Your Honor. It was a public defender.
Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because
I mean,
at that
well,
time, we have a deal
For
that my clients
Pete's
will.
sakes.
Your Honor, I believe we sent discovery to both the public defender. I believe Ms. Stedman was also on this case prior, and the discovery was also sent to her.
And you're saying from neither prior attorney did you get discovery?
No, Your Honor.
Can you send it to him now? Because I'm setting this for exam. I'm not playing around with this anymore. Send a discovery to them. This will be set for preliminary examination in person, September 9th, 2025, 9 a.m. That's before me. I'm gonna quit playing games. Bond continued.
Thank you, Your Honor.
can you believe it? An attorney you're actually paying is ready to take a plea deal without even requesting discovery. That's just mind-boggling. Honestly, a free, overweight public defender could probably provide the same level of representation, or maybe even better. It's like paying luxury prices for a bus ride you could have gotten for free. The craziest part, The lawyer completely drops the ball, but still walks away with money from the defendant. If he had just done the basic homework, this case would already be closed. Instead, he'll bill for extra work later, reviewing discovery, showing up again, basically getting paid to fix the mess he created. It's shocking how the system allows incompetence to turn confusion into profit. And seriously, how did this guy even pass the bar?